Part 2. The Basics of Personal Bankruptcy. In this section, we will briefly explore the basics of personal bankruptcy. You will learn, what is bankruptcy? How does Chapter 7 bankruptcy work? How does Chapter 13 bankruptcy work? What is a bankruptcy discharge and how does it operate? What is a reaffirmation agreement? How to reestablish credit after bankruptcy? What is bankruptcy? Bankruptcy is a federal law that allows individuals over the age of 18, married couples, and businesses to eliminate or restructure their past due debts when they have financial difficulties. Because it is a federal law, it applies throughout the United States. Individuals experiencing significant financial difficulty may consider bankruptcy as an option. When you file bankruptcy, it must be determined which bankruptcy type best suits your situation and which type you qualify for. There are generally two different types of bankruptcy for individuals. They are Chapter 7 bankruptcy and Chapter 13 bankruptcy. How does Chapter 7 bankruptcy work? Chapter 7 bankruptcy is the most common form of bankruptcy. This type of bankruptcy is known as straight bankruptcy. To file this type of bankruptcy, you may seek the help of an attorney or legal professional, choose to go it alone, or use a self-help service company. It is critical that you or your attorney are diligent about gathering your information, preparing it carefully, and following through on details. When you file Chapter 7 bankruptcy, a court-appointed attorney, known as a trustee, is appointed to assess your financial situation. The trustee is working on behalf of your creditors. The trustee may decide that some of your assets must be liquidated to satisfy your creditors. You may be able to keep some personal items, and possibly real estate, depending on the law of the state where you live. Now let's review how a Chapter 13 bankruptcy works. Chapter 13 bankruptcy is also known as wage earner bankruptcy. With the help of a bankruptcy attorney, you would file a proposed Chapter 13 repayment plan to the court. In a Chapter 13 bankruptcy, you can usually keep your property, but you must have regular income and may not have more than a certain amount of debt as set forth in the Bankruptcy Code. Repayment plans in Chapter 13 can range from 10% to 100%, depending on the debtor's income and the amount and nature of the debt. The court must approve your repayment plan and your budget. If approved, a trustee is appointed and will collect the payments from you, pay your creditors, and make sure you live up to the terms of your repayment plan. Your Chapter 13 bankruptcy must be completed within 3 to 5 years. You will also be required to submit updated financial statements to the court annually. Chapter 13 bankruptcy has so many unwritten rules and local customs that you should seriously consider seeking a bankruptcy attorney. What is a bankruptcy discharge? A discharge is a court order which states that you do not have to repay the debts included in your bankruptcy filing. Some debts cannot be discharged. For example, most taxes, child support, alimony, most student loans, court fines and criminal restitution, and personal injury caused by driving drunk or under the influence of drugs. The discharge only applies to debts that originated before the date you filed your bankruptcy petition. Also, if the judge finds that you received property inappropriately, that particular debt may not be discharged. It is important to list all your property and debts in your bankruptcy schedules. The judge can also deny your discharge if you do something dishonest in connection with your bankruptcy case, such as destroy or hide property, falsify records or lie, or if you disobey a court order. Some creditors hold a secured claim. For example, the bank that holds the mortgage on your house or the loan company that has a lien on your car. You do not have to pay a secured claim if you included that debt in your filing, but the creditor can, and quite probably, will take the property. You can voluntarily pay any debt you wish to pay. If you decide to pay a debt and keep it out of your bankruptcy filing, you will have to sign a reaffirmation agreement. What is a reaffirmation agreement? A reaffirmation agreement is a promise to pay a debt that was not included in your bankruptcy filing. Some people may have a special reason why they want to keep the debt and ultimately pay it. For example, you may want to work out a plan with the bank to keep your car. To promise to pay that debt, you must sign and file a reaffirmation agreement with the court. Reaffirmation agreements are under special rules and are voluntary. They are not required by bankruptcy law or by any other law. Reaffirmation agreements must be voluntary, must not place too heavy a burden on you or your family, must be in your best interest, and cannot be canceled any time before the court issues your discharge or within 60 days after the agreement has been filed with the court, whichever gives you the most time. If you are an individual and you are not represented by an attorney, the court must hold a hearing to decide whether to approve the reaffirmation agreement. The agreement will not be legally binding until the court approves it. If you reaffirm a debt and then fail to pay it, you owe the debt the same as though there was no bankruptcy. The debt will not be discharged, and the creditor can take action to recover any property on which it has a lien or mortgage. The creditor can also take legal action to recover a judgment against you. Filing bankruptcy is not the end of the world, as you may have heard. Believe it or not, there is life after bankruptcy. The good news is, even after bankruptcy, you may not have to survive without credit. Filing bankruptcy does not prevent you from getting new credit. In fact, a special type of lender markets their service to recently bankrupt individuals or families. Furthermore, the Bankruptcy Code protects debtors from discrimination based solely on a bankruptcy filing. You cannot be legally terminated or denied credit solely because you are a debtor in a bankruptcy proceeding. You can, however, be turned down based on your total financial history. Before you begin creating new debts, it is wise to remember that too much credit may be the very thing that led you to the bankruptcy in the first place. Most experts suggest that in the first couple of years after a bankruptcy, you avoid making any substantial financial changes. Bankruptcy is designed to lift the financial burden from your shoulders and give you a fresh start to rebuild your credit. If bankruptcy is ultimately your best option, the first step to rebuilding your credit after filing is to stop listening to people tell you that you have ruined your credit for life. This statement is untrue. You need to think positively and keep in mind that you have buried all of your mistakes, bad decisions, and the overspending that initially got you in serious debt. Bankruptcy means a new beginning. You are now ready to build a new financial life for yourself and your family. Once you have discharged your debts, it's very important that you begin to reestablish a good credit rating. Here are two options for reestablishing new credit. Option 1. You could apply for a loan to purchase a car. If you have filed bankruptcy, you may need to ask a family member or a friend who has good credit to co-sign with you. This auto loan will appear on your credit report as a joint account with a person who co-signed for you. As you make your car payments each month, the bank will report these payments as current. This will demonstrate to future credit lenders that you can handle installment credit payments responsibly. Be sure to make the payments on time every month. Option 2. You could also apply for a secured credit card from your bank. As you charge purchases on the secured credit card, your balance will be reported to your credit report. As you make on-time monthly payments, the credit card company will report those on-time payments as current. This will demonstrate to future credit lenders that you can handle revolving credit payments responsibly each month. You need to be sure you pay these amounts in full every month. Take what you have learned and be sure not to fall back on your old habits. Credit cards are useful if used properly. If you are carrying balances on your credit cards, then you're most likely not acting in a financially prudent manner. Patience is important in this process of rebuilding a good credit history. Remember, when you sign an application for a credit card or a loan, you are legally responsible to pay back the money you borrowed on time and with interest. We recommend that you slowly develop your new credit history. Don't make the mistake of applying for too many credit cards or for a loan that is larger than you can handle. Start slowly. Be responsible when spending money. Keep track of how much you spend and most importantly, pay your bills on time. This concludes the Basics of Bankruptcy section, and we will now continue to Part 3, preparing for your budget briefing session.